Welcome to Breaking Ties, Destination Divorce. This is your go-to source for practical advice and support while you go through the divorce process. Join us each weekday for a quick chat where we'll cover a variety of topics such as child custody, property division, and self-care. Together, we'll explore emotional, financial, and legal aspects of divorce and help you find the best path forward for you and your family. Here's your host and Certified Divorce Financial Analyst professional, Mike Fulkerson.
Hello and welcome to Breaking Ties interview series, where we talk with professionals who assist those getting through the divorce process, and we get a lot of great answers to many of the questions you might have. I'm your host, Mike Fulkerson, financial advisor and certified divorce financial analyst professional, and with me today is Margaret Zuleger. Margaret is a collaborative divorce attorney with her own practice. We're going to get it straight from Margaret today. It's going to be fantastic with the information. I want to welcome Margaret to the podcast. How are you, Margaret?
Great. Thank you.
Excellent. Why don't you share a little bit about yourself with our listeners?
Okay. Well, I've been an attorney since 1992. I went to Northwestern Law School. I've been doing family law exclusively since 2008 after I went through my own collaborative divorce. So I know where my clients have been, and I've been in my own practice since 2011. My office is in Arlington Heights, but I cover all the collar counties. Most things are Zoom now anyway, so it doesn't really matter.
Right, exactly. Yeah. Yes. And so that's Arlington Heights, Illinois, right around Chicago areas where we're out of. And so Margaret has a ton of experience. So this is going to be a great week of podcasts because we're going to have her every day this week answering 2 or 3 questions each day. And you're going to want to see them all. Now, we're going to start off with the basics a little bit, Margaret. And can you help us with kind of defining what collaborative divorce is?
Yes. Yeah. So collaborative divorce is a non-adversarial method of getting a divorce where both spouses have their own attorneys, and we work through all of the agreements through a series of settlement conferences until we have all of the agreements in writing, and only then do we file in court and finalize.
Oh, all right. Very nice. That's, for a lot of people, I think they think of divorce as being more the traditional litigation route that you often hear all the terrible stories about. Now, yes. When it comes down to the collaborative divorce and using that particular process, how does someone know if it's right for them?
Well, if you and your partner want to have a settlement-only process and promise from the beginning that nobody's going to go to court and file any motion and have the judge decide anything about their life, their money, their children, anything, then collaborative is a good choice for you. But you both parties have to agree that it's settlement only. The attorneys are also sign that same pledge saying this is settlement only. So the attorneys themselves cannot become the litigators in a case. So we can't start a collaborative case and then if things get a little dicey, say, okay, fine, now we're going to the judge. No. Collaborative is settlement only, meaning the attorneys are actually even disqualified from going to litigation. So it keeps us, the attorneys, it keeps our litigation hats off. We don't threaten things. We don't even, we advocate for our clients. And so we tell our clients, what would happen if a judge had to get involved, in our opinion, but we don't threaten and we certainly don't go. It's settlement only. And that doesn't mean it's easy, but just settlement only.
Yeah, right. I don't think any part of the divorce process, no matter which one you're using, has probably ever been titled easy for the most part. So There's always something going on. Right. And so we got the collaborative divorce process. Now, what qualifications should we look for in a collaborative lawyer?
Well, somebody who's had the training. In order to be a collaborative attorney in Illinois, you have to take a basic training, we call it, and mediation training, and then keep up with your training. So, join the it's called Collaborative Divorce Illinois, and that's the website. And we have the initial training, then we have ongoing training where we meet for practice groups and we hear from special speakers and we talk about how to always just improve the collaborative option that we're offering people. The collaborative divorce Illinois is actually, so in a collaborative case, you have 2 attorneys at a minimum for each client, but we can also have a mental health professional who acts as a coach. They're involved to help the communication in the meetings and also kind of maybe help with some of the emotional challenges between the meetings. And then we can also have a financial neutral who is either a CPA or a certified divorce financial analyst, and they do all the gathering of the documents, the financial affidavits of parties, presenting marital estate balance sheets, running guideline support to kind of just do all that stuff. We don't need that for every case. We don't need a coach for every case, but every case could have like the full support. If you need the emotional support or the financial support and education, then the full team is really your best option.
Wow. Yeah, that's great. And we're actually going to dive into more of that team structure and figuring out, what pieces, parts someone might need in one of these episodes this week. So we're really going to break it down and find out what's best for everyone out there. So now,
sounds good.
This actually concludes our first day. I mean, goodness, we jump right in. I mean, when we're talking divorce and the process, it's going to move pretty quick and it's going to be pretty detailed. So I want to say you guys got to come back tomorrow and watch the rest of the week of these episodes as we continue our discussion on the collaborative divorce process. And Margaret and I, we'd like to thank you for joining us today on this episode of Breaking Ties, the interview series. Should you have any questions for Margaret, you can find her contact information in the description. Remember, divorce is not the end of your story. It is the start of your next great chapter. And we will see you tomorrow. Take care. Welcome back to Breaking Ties, the interview series. This is day 2 of our week-long series where we really talk with a professional who assists those getting through the divorce process, and we get a lot of great answers to many common questions that listeners have. I'm your host, Mike Fulkerson, financial advisor and certified divorce financial analyst professional. And with me today, again, is Margaret Zuleger. And for those who didn't tune in yesterday, Margaret is a collaborative divorce attorney with her own practice. How are you doing today, Margaret?
Great. How are you?
Not too bad. The sun's out for a change, so hey, you got to love it.
Nice.
Well, I know our listeners had some really good information yesterday, and if you didn't actually catch that episode, then you're going to want to go back and hear what Margaret had to say about the collaborative divorce process. And today we're going to continue that conversation that we started yesterday with Margaret, and we're going to start it off with, how long does a collaborative divorce typically take?
Well, of course, the answer depends on the couple, how complicated everything is, whether they have children, whether they have a complicated financial picture, whether there are other issues going on. But basically, it takes as long as it takes, but the more the parties can come to their agreements, the less time the attorneys need to take helping them come up with their agreements. So conflict is expensive, agreement is efficient. So it's really up to the parties. We just take them as they are and help them as efficiently as we can. We know it's an expensive process, so and another little thing we say is that and this holds true for regular litigation as well. The process moves as quickly as the slowest party involved. And it's pretty normal actually to have 2 parties like not on the same page. Usually one of the parties is a little more the instigator. Maybe they want it done as, yesterday. Other person is still a little shell shocked. Like, I don't even want to be here. I'm hoping you change your mind. Don't push me. I need to take my time. This is all just upsetting. This is never what I imagined. And that's understandable. So the whole team, the whole collaborative team, including that person's partner, has to give that person time to catch up, get on the track, so to speak.
Yeah.
But they do have to engage. I mean, they can't just, just like in regular court, you can't delay it forever, but they're just different paces. So it really depends on the couple.
Right, exactly. And you're right. Some people, they're ready to go, and other people really, they got to take some time to process and kind of figure things out. And actually, it's also, everybody moves at a different pace. Some people are just a little bit more methodical, and some people are just more spontaneous. So you're going to have those different viewpoints during, the process for whoever happens to, be going through it at that time.
Right.
Now, we talked a little about this yesterday with regards to a team aspect in collaborative divorce. So other than the attorney, what other professionals might we pull in if we need them? Or is there like professionals who are just standard part of the team usually all the time?
Well, I'd say a coach is a pretty standard part of the team, just at least to get them in place. They don't necessarily have to be there for every single meeting if everything is going well, but it's good to get them in place to help start the process, because at the beginning of the process, we do ask both parties to state what their goals are and their concerns. And so it helps to have the coach kind of help each party work up and get ready to express that in the first meeting. I mean, I do that too, but if I have a coach, I'm going to use him or her to really help prepare. And then we can also have, so that's the coach. And the coach also often handles all the parenting. So sometimes we have the couple meet with just the coach offline and work up the parenting plan. So again, you're not paying the attorneys to do that, although we will, if there's any issues, we'll jump in, but oftentimes the coach will kind of do the parenting thing and then bring the agreements back to the team, and the attorneys turn that into the final document. The other professional is a financial neutral. So they help the parties, put together their budgets, their financial affidavits, gather all the documents. They put together the balance sheet. They present it to the team. They, based on what each party wants to see, they show like what one kind of division would look like versus another kind of division. They run the guideline child support and maintenance if applicable. They talk, they help everybody figure out like what income to use if there's any question about that. If it's, like a self-employed person versus just like, W-2 employees are easy. Income is income. Self-employed people, it's more complicated. And a financial neutral, from a neutral standpoint, can be the person that kind of figures out what is the income here, or at least present to the team. Well, we could look at income this way. We could look at income that way. What do you, as the divorcing couple, what do you want to do? What can you agree on doing?
Right. Exactly. So, yeah. So, I mean, anytime you need something, you got it there from that standpoint. When it comes to collaborative divorce process, it sounds like you guys will pull in whoever you need to help the process along.
Right. Yeah. We don't always use a financial neutral. If the parties kind of know what they want to do and there's nothing other than like a couple of 401ks, bank accounts, and a house, we don't need a financial neutral. And everybody kind of understands, what a division might look like, what it might mean down the road. We don't need a financial neutral. So we're not trying to give more service than the couple needs. So it's really case by case what they want, what resources they want to use.
Right. Exactly. Case by case, indeed. Now, I think we can probably agree that the litigation route is probably the most expensive a lot of times as far as costs go with the divorce process. How does the collaborative divorce process factor in when it comes to costs?
Well, I mean, a challenging collaborative case will certainly be less expensive than a terrible litigation case. That doesn't mean that either are going to be cheap, because time is money, right? Conflict is expensive. Do you need, 3-4 meetings, or do you need 20 meetings? Do you go back and forth on the documents 25 times, or do you pretty much sign the first draft after you've come up with your agreements? So it's less, but it's not like the least expensive. Probably the least expensive if the parties know what they're doing and one party is willing to be unrepresented by an attorney. And so there could just be one attorney, but that attorney can't represent both parties, but can represent one. The other person can be unrepresented. So collaborative isn't the cheapest, but it certainly is not it doesn't spiral the way litigation does, because again, you're not throwing your power to the judge to set briefing schedules and hearings and discovery and this and that. In the collaborative process, there may be challenges, but we don't waste any time in court. We just get to the resolution. We decide what we need. That information is provided. We make decisions about it. Done. Whether it's easy or hard, that's the process. We don't go to court for that, to have that resolved. Right.
Exactly. Yeah. And just saving that court process alone, can actually save you money.
Oh yeah, there's so much wasted attorney time and litigation. Once you get in the system, you're pretty much there on a monthly basis. And sometimes it's just to say, well, Your Honor, we're working on things. The judge will say, okay, fine, see you next month. Great. But I'm charging for that because I have to do that. But does it really advance the case? No. Most of the time, people would rather pay me to be actually working on the case. Like finding resolutions in a meeting, working, not just going to court, getting a date, telling my client, okay, well, the next date is X. But that's traditional litigation, because once you file, you're in the system, and then those court appearances start. In a collaborative case, you don't file anything until we're ready to finalize. We save all court appearances except for the final court appearance.
Right. And that can really work out in the client's favor in that regards.
Absolutely. It's a better use of money to pay the attorneys to really work on resolution.
Definitely. Well, all right. Once again, fantastic information, Margaret, because this concludes day 2 of 5. And for those listeners who didn't catch yesterday's episode, you want to go back out there and listen. Every day has different questions, and Margaret provides a wealth of knowledge. So you're going to want to also join us tomorrow as we continue our discussion on the collaborative divorce process. Margaret and I would like to thank you for joining us again today on this episode of Breaking Ties interview series. Should you have any questions for Margaret, her information's in the description, so just reach out to her. She's happy to help. Divorce is not the end of your story. It is the start of your next great chapter. Have a good day, and we'll see you tomorrow. Hi, and welcome back to Breaking Ties, the interview series. Today is day 3 of 5 with our guest, Margaret Zuleger, and she's going to be talking with us more about the collaborative divorce process, as she's an attorney with her own practice. Now, before we begin, if you haven't been to the previous couple days of the interview, I highly recommend you go back and check them out, because every day has different questions, and Margaret is providing such great information. Now, when we look at moving forward here, we're going to, get some more questions today, tomorrow, and the next day from Margaret, and she's going to really continue on with the series. Welcome to the podcast, Margaret.
Thank you.
Now, we've really been going over how the collaborative divorce process has been moving along, who's on the team. Really, let's look at that first meeting and what should we expect during the first meeting with the collaborative divorce team?
Yeah, so that's the first team meeting. And so we have our full team assembled if we're using the other professionals. So it's both attorneys, a coach, and a financial neutral, and the parties, obviously. And so first we go through the collaborative participation agreement. And that's what makes it a collaborative case. That's the agreement saying we're going to act in full, honesty, transparency. The attorneys are disqualified if anybody goes to court, and this is settlement only. And so if everybody agrees, of course, they've seen the agreement before, but everybody signs at that first meeting after we go over it. Then we ask them to both take time to express their goals and concerns. There's the high-level goals and concerns, not, I want the china cabinet in the, it's like about pace, like how quickly they want the case to move. Like, do they want to go as quickly as possible? Do they not want to be pushed? Big things like, changing locations, houses, not like specifically if you want to keep the house, how, but just like, I would like to either sell the house and move on or keep the house, for various reasons. So like just those kinds of goals and concerns. Both parties expresses their concerns. And what I really like about that part is sometimes when somebody expresses a concern, like, I'm really afraid you're going to, the other person will hear that and say, oh my God, no, don't worry about that. I'm not going to do that. But you see that the communication between the parties has usually broken down so badly that they have not been talking. And so they don't know what the other is thinking. So there's a lot of fear around that unknown. Or there's been a case where the communication is broken down. One person is talking all the time. Another person's clamming up because they don't want to fight anymore. And so they don't say anything. But so the person who's talking all the time or has been talking thinks that there's an agreement. And then they get into the meeting and they say something. Then the person finally feels comfortable saying something. They can say, no, I didn't agree. I just didn't want to argue with you. So there's a lot of so you're trying to get, our goal is to see where is this couple on the same page? Where do they have joint goals once everybody expresses it? And where are they not on the same page? And therefore, this is what we have to work on. We have to work on the areas where they don't agree. We have to find a way to help them resolve their differences until they get to a written settlement agreement so that the case can be finalized.
Right. Yeah, I think you hit it on the head there when you talked about communication and the various types of communications that are available for different people and how they approach it. And so, there's a lot of, just getting comfortable that, everybody has to get a feel for everybody else and just kind of make sure you're on the same page.
Yep.
Now, a lot of times we think of divorce and we think the big thing is the finances, and it is. And so during the collaborative divorce process, how does finances get divided up and looked at?
Well, first and foremost, it's up to the couple. Basically, you can divide your assets any way you want, and as long as it's not unconscionable, the judge will approve it. So the attorney's job is to make sure that whatever agreement the parties are coming up with, that it's going to be approved by the judge. And so it has to be not unconscionable. So, but it doesn't have to be 50-50. Oftentimes people decide to divide things 50-50 because in reality, if you can't agree and you have to go to court, judges typically divide everything 50-50. The statute actually says, however, that the marital estate shall be divided equitably without regard to marital misconduct. So it doesn't say 50-50. It doesn't have to be 50-50. But it's also not 50-50 because of marital misconduct. Because, people, usually the person who's feeling bad about something, or because they've been, they feel like they've been treated badly, they think maybe they should get a little more to compensate, but that doesn't happen. But anyway, so the parties, first and foremost, they agree. If they can't agree, then the attorney will tell their respective clients, hey, I hear you're not agreeing, but just so you know, if we went to court, probably it'd be 50-50. So let's go back and figure out what that looks like. But there's different ways to do 50-50. 50-50 doesn't mean every single asset in half. 50-50 is you keep this, I keep that. And as long as it balances, maybe a little equalization payment, or, it just depends. But if it gets really out of whack, but a judge would find unconscionable a division like a 90-10 division. And the person that makes way more money is keeping 90% of the assets. And the person who's making very little money is keeping 10%. The judge would say, I know this is your agreement, but I find it to be unconscionable and I won't enter it. So, you have to make sure it's within the realm of reason. And the farther you get from 50-50, the more the judge might say, why would I find this not unconscionable?
Right. Yeah, exactly. So you still have things you have to satisfy from just, making sure it's fair for everyone.
It has to be not unconscionable. The judge,
right.
Sometimes the judge says fair, but the statute, and they're only really required to say, I find it to not be unconscionable. They don't need to say, I would have decided things the same way, or, let me get my calculator, see if it's 50-50. No, it has to just be on its face, not unconscionable.
Right. That's great. Now, in addition to the finances, I know through my divorce, we had kid stuff to take care of. So we're looking, how does the collaborative divorce process work with, say, child custody and support?
So actually, there's no such thing as child custody in Illinois anymore. There's just parenting time and decision making.
Oh.
So yeah, that used to be the word, but it's not in any of this. That's not the word anymore, because it kind of makes kids seem kind of like personal property or something.
Right.
I don't know. So the parents. It depends. If a lot of times there's not really an issue about the parenting schedule and decision making. But if there is, then we would want a coach involved, because then we would choose a coach who's also like a child specialist, and we would have the parties meet with that person offline to work up the details, parenting schedule, decision making, other things like introduction of significant others, or use of substances, or who can be a child care provider, who can't be a child care provider. All of those things we tend to have a child specialist work on, and then they, with a couple. And again, that saves money, because you're not having the attorneys who are at a higher billable rate, and two of them, we're not talking about those things in the meeting if the parties can work it out with the child specialist. Now, if there's something that can't work out, then absolutely they bring it to the meeting. If they don't agree, then the joint meeting, then the attorneys get involved. And we say, okay, well, in our experience, when this has been an issue, sometimes couples do this, or even more heavy-handedly, when there's been this issue and it goes to court, then this is what happens. So, again, let's come back to the settlement table, and you have to be within the realm of reason,
Exactly. Right. Yeah. And that is it. I mean, the divorce process is not meant for one person to take advantage of another person, no matter what
No.
they did, kind of thing. It's all meant to just, get things processed and divided up in a way that everybody's kind of happy, but everybody's kind of not happy.
Yeah,
So,
if one person's happy, one person's sad, then that's not probably a good agreement, because then that means there was no compromise.
mhm.
And, so it has,
Y-
yeah.
yeah, you gotta have it both ways.
Yes.
So, all right. Well, hey, we've made it through day 3 of 5 of our interview series. And if you haven't caught the first 2 episodes, go back and check those out. And don't forget to join us tomorrow as we continue our discussion on collaborative divorce with Margaret. We would both like to thank you today for joining us on this episode of Breaking Ties, the interview series. Should you have any questions for Margaret, her information's in the description. You can reach out to her. Divorce is not the end of your story. It is the start of your next great chapter. We will see you all tomorrow. Have a great day. Hello, and welcome back to Breaking Ties, the interview series, where we talk with professionals who assist those getting through the divorce process and answers many of the common questions that you might have. Now, we are on day 4 of 5 of the series with Margaret Zuleger, and Margaret is a collaborative divorce attorney with her own practice. How are you doing today, Margaret?
Great. Thanks.
Well, I tell you what, it's been great to have you on this week. And if our listeners haven't checked out the first parts of this series this week, Monday, Tuesday, Wednesday, I think you got to go back and listen to it, because Margaret's been answering some really great questions on collaborative divorce, sharing a ton of information, and I think you all will appreciate that. So go back and check it out if you haven't done so already. Now, we're going to continue on our discussion, and we've walked through a lot of this kind of the process last time and the meetings and a little bit of what happens. And we're going to continue that. So continuing with the kid questions, we've got, can we use the collaborative process to create a parenting plan?
Yes. So the collaborative divorce process gets you to all of the final written documents that you need in order to get a divorce. So in every case, you need a marital settlement agreement. That's where all the financial information is described and allocated. If you have children, minor children, you also have to have a parenting plan or allocation judgment. This allocation judgment is what you work up in the collaborative process, and the attorneys draft it, and then the parties sign it, and then it's approved by the judge.
Excellent. Yeah, I mean, you would have to assume that the collaborative process would handle children and all the pieces, parts that go with it as well.
Absolutely. Yeah. And we're very child focused if there are children. In fact, that's often why a couple will choose collaborative if they have children, because they're going to try, their goal is to get divorced as peacefully as possible so that they can go on and co-parent their children, because they'll go from spouses and co-parents to just co-parents, but they're still going to be parents of these children. And even if the children are not minors, they are still parents of the children. There can be some real challenges around parenting, not really parenting, but sort of parenting with adult children.
Right.
There are issues with adult children. There's payment of college. There's sometimes there's like health issues. How are we going to deal? How are these parents going to deal with the child's health issue, even if it's not specifically controlled anymore by the court? If they're over 18, sometimes the parents really want to find a way to continue to support their child if their child has a special need or just general, early adulthood angst. So.
Right. Well, I think as a parent, really, you're almost always parenting. I mean, even when I go back to see my parents, I just slide right into the kid role with my parents. Even it's so uncanny how that works out.
Yes. And you still are parenting your children and your adult children, just in a different way.
Exactly.
Hopefully in a different way.
All right. So we've got the finances, we've got the kids. What happens once we reach a collaborative divorce agreement?
Well, once everything is written and signed by the parties, then the attorneys also prepare all the documents that you need to get before the judge. So the petition for dissolution of marriage, the appearance, there's usually, like, depending on the county, a stipulation saying that you're ready for prove up, getting the date for the prove up, or if you're doing it by Zoom, an affidavit for prove up. But anyway, getting all the documents together, signed where needed, including any division of retirement. So if the parties are dividing an IRA, a pension, basically any retirement asset other than an IRA, then they need a quadro, qualified domestic relations order. And that's what divides a 401k or a pension or a 403b or whatever. And so that document also has to be prepared. And I always want it to be prepared and entered at the time of the judgment. It can be done afterwards, but I don't like that's not a good idea. So that's not, but we know that. So the attorneys are, as the agreements are coming together, if we know we're going to need a quadro, we get working on that so that it's ready for the finalization. So we're not waiting. Once the parties are ready to get divorced, we get them divorced. That's our job.
Right, exactly. You made it to the end. Let's just get it finished without delay.
Yes, so people can move on. It's hard. It is. And the sooner people can move on and start healing, the better.
Absolutely. Now, so we've got all this stuff together. Everything's ready to go. Do we have to make a court appearance to finalize the divorce?
Well, it used to be yes, and in some counties it still is, and it's also up to preference. But so generally speaking, prove-ups, that's the finalization, are via Zoom. So you do appear, and your attorney just asks you a bunch of questions. The answer to everything is yes. The other side kind of repeats some of the questions, then the judge signs the judgment. So we used to be in person, obviously, but now it's typically over Zoom. There are some counties that are starting to allow a prove up by affidavit, which is just like preparing another document. And so you don't need a court appearance, but you need to prepare that document that needs to be signed and filed. So there's still, it's an option. I almost kind of like just the Zooms better. I mean, just the in person, because it's a finalization. You were there at the beginning, you were there at the wedding. I kind of like, the final court appearance, just one last time, just, I don't know. That's just a personal preference. The prove up by affidavits, is becoming an option in most of the counties now.
Okay. Yeah, that's great. I mean, I didn't even really think about doing any of these processes via Zoom.
Most courts, it's Zoom's your only really your only option. Even if you're self-represented, just in in everything.
Right.
You can come in, some courts allow in person, but they really prefer Zoom for most things. Things are just kind of routine, like approve it. Like the finalization is pretty routine because you don't get to the finalization date until you have everything signed. So it's not the time to argue about things or ask the judge to decide anything. It's just to have the judge rubber stamp your agreement, basically, and finalize it.
Yes. Man, once again, today has been fantastic because we have reached the end of our 4th day of the interview series. And I can't thank you enough for coming on and sharing the information that you're sharing, Margaret. This is fantastic.
You're welcome.
Now, for those who caught today's episode as their first episode, this is a 5-part series. So we've already got 3 days in the books. You're going to want to go back and listen to those. They have different questions, and they all pertain to the collaborative divorce process. Then you're going to want to come back tomorrow and join us as we continue our discussion on the final day. Margaret and I would like to take a moment to thank you for joining us today on this episode of Breaking Ties, the interview series. Should you have questions for Margaret, she's happy to answer them. Her information is going to be in the description here of the podcast. Divorce is not the end of your story. It is the start of your next great chapter. And with that, Margaret and I will see you tomorrow. Take care.
Bye-bye.
Hello, and welcome back to our 5th and final day of the week-long Breaking Ties interview series. We have been chatting this week with Margaret Zuleger, and she is a collaborative divorce attorney. And let me tell you, this week has been fantastic for information. And we're going to wrap it up with some more great information from Margaret. And Margaret actually has her own law practice, which is actually even more cool, I think. So we appreciate her coming on, and welcome back to the podcast, Margaret.
Thank you.
How's your day going so far?
Pretty good.
Excellent. Well, I tell you what, it's been great. Our listeners, really are getting a lot of information, and I couldn't ask for more. It's been fantastic. Now, we're on the last day of the series here, which is kind of a shame, if you will. It's always been fun to have these discussions and learn more, because I even learned through this whole podcasting process. But we're going to finish up here with a couple process questions, because we talked about getting all the way through the process and everything on all the steps it takes. So we've talked about a lot of the easy stuff, if you will, as far as that goes. But sometimes there could be drawbacks of a collaborative divorce, and would you be able to share a few drawbacks?
Sure. Well, I mean, one drawback would be if the process doesn't end in divorce because one person left the process and went to court. So that's always a shame.
Right.
And we try, so you try to, not every case is appropriate for collaborative, and the collaborative professionals try to screen for cases to make sure that there's a really good chance of success. I mean, most cases do end in a divorce successfully, but sometimes the process ends. Sometimes one person is just really not willing to compromise or listen to reason or whatever, and they just cannot be convinced by their attorney that going to court would not be a better solution, and they just don't believe it. I can't believe a judge wouldn't blah 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 blah. Okay, fine. You're gonna find out, and it's a shame because everybody has to start over. Both parties have to get their own attorney. The work that's been done can't be brought into litigation. I mean, the underlying data can be recreated, but what stays in what happens in collaborative stays in collaborative. So people really have to start over. And so then you start litigation with a real sense of failure that, one person's probably pretty upset that it's going to litigation, but if you still want to get divorced, then that's what happens.
Right.
So to me, that's the only drawback in a collaborative case that you don't have in litigation. In litigation, unless you withdraw your petition and don't proceed with the divorce anymore, you are going to get divorced.
Right. Yeah, exactly.
So, yes.
Yeah, and it goes back, I think, to the beginning when we talked, which was everybody's got to be vested into the collaborative process.
Definitely.
And so if you're not, or somebody's kind of, let's say, defensive, or they're not willing to compromise, then, like you said, collaborative is probably not the best choice for them.
Right. And or if they're not willing to be fully transparent. I mean, that's part of the agreement too, that everybody, full transparency. If a document is requested, then it's given. There's no saying you don't need to see that, and since we don't have a case filed, we can't subpoena the documents either. So it's full disclosure. Whereas in litigation, somebody could be difficult, although it turns out that always backfires on the person who's being difficult eventually. But, you can take a person who's being difficult and say, okay, fine, it's going to increase the cost of litigation, but I'll subpoena your bank and your employer and your investment company and your whatever, if people aren't giving the documents.
Right.
So that's like an aggressive, expensive thing to do, but it's something that you can do in litigation. That the collaborative process, we say we're not going to do that. We're saying everybody gets everything they want. There's no withholding anything. But if somebody started the process and they weren't being honest about their willingness to do that, then sometimes that can break down the process. So that's one thing you screen for. Is somebody willing to be honest and transparent? If so, then collaborative will be successful. Mm-hmm. Unless there are other issues. Sometimes they're like emotional, like mental health issues too. It's not about the documents. It's not about the money. It's about the kids or something. And
right.
That's almost harder because then there's not even an even subpoena to get the answer for. It's you just have to you have to work it out in the
yes.
But again, but working it out in the collaborative process is better than having it worked out for you in litigation, because in that situation, if you can't agree on parenting, then a guardian ad litem is going to be appointed. That's an attorney who has special child psychology training. They do an investigation of both parents. They talk to neighbors, friends, family, teachers, anything, and then give their recommendation to the judge about what the parenting, schedule and decision-making should be. So, but then again, you've totally lost control. Once the GAL is involved, it doesn't matter, Doesn't matter what you want. If the GAL doesn't agree that that's in the best interest of the children, then the judge 9 times out of 10 is going to order what the GAL recommends. And so, so I mean, it's not like it's great in litigation at all.
Right. No, litigation is not any fun. Hardly any of the process is fun, no matter which way you take.
Right.
But litigation is definitely much
Yes.
more difficult as far as
Yes.
things go.
And talk about money. I mean, GALs charge attorney's fees on the higher end of attorney's fees. So then you have 3 attorneys involved in litigation, both spouses and the GAL. So that gets very expensive very quickly.
Absolutely.
Mm-hmm.
Well, once again, great information. I want to, kind of just get some final thoughts from you that you'd like to share with the listeners.
Yeah. So I think if divorce is going to happen, then I think collaborative is really the healthiest way to go through the divorce process. You are supported by a team. Everybody's encouraging everybody's best behavior, not their challenging behavior. And it's just really the best way to get through the process with everybody's interests in mind, and for the benefit of the children if you have them, so you can go on to co-parent after the divorce. And the divorce process itself hasn't made the relationship worse than it was coming into the divorce.
Right, exactly. Because there is life after divorce, and you
Absolutely.
still have to work with your co-parent if they're, if you have kids and stuff. And so,
Yep.
you still got, as a divorced parent, you still got your work cut out for you
Yes.
from that standpoint. But at the very least, you're able to move on in a lot of other aspects of your life, getting through the process and getting it through it as, say, painlessly as possible.
Exactly.
I think is probably the number one goal for most people getting a divorce. So collaborative process is definitely a good way to go for those goals.
Yes.
All right. Well, it's been great, Margaret. This ends our week-long series. Once again, the information you shared is nothing short of amazing, and a little insight into how things work is always good for people to just be knowledgeable on what their options are out there.
Right.
So, our listeners, if you haven't seen the previous 4 days of our discussion, I really recommend you go back and look at the whole series. Margaret did share some amazing information that I think everybody can take away a little something from. And for the last time, we're going to thank you for joining us on Breaking Ties, the interview series. And if you feel Margaret's services really could help you on the collaborative divorce side, don't hesitate to reach out to her. Her contact information is in our description of the podcast here. Divorce is not the end of your story. It is the start of your next great chapter. And with that, best of luck and take care.
Bye-bye.